all the participants benefit out of this. And one more suggestion, Dr. Makhija, is I would want our members to, our IPNet to seriously think of going back to the drawing board and equip our members to we take an informed decision rather than take this entire CIP process in a casual way. Certain observation in this judgment is shell shocking. So therefore, over to you, Dr. Makhija. Thank you so much for joining in. I recognize the presence of Sahu. I just could see his name. I'm sure he might not be knowing me. Good evening, sir, and my dear friend Uday. This particular webinar, the combined wisdom of all these 156, it's like a 2020 match, last 2 hours. You get sixers and fours, quite often. So it's just 157 now. Over to you, Dr. Makhija. Good luck to you. Let us hear from from your wisdom how to handle this particular situation now. Thank you so much. Over to you, sir.
Right. Thank you. Thank you, Mr. Shankar Panicker. I think beautiful words. And this judgment is definitely, you see, ruffling certain feathers. People are slightly confused what to do, what is going to be the fate of IBC, what is going to be the fate of IPs itself, and also about the IBC ecosystem. But before I start, friends, let's do 2-3 things. Namrata, if you can hear me, since you are there, of course you are one of the co-hosts, so please keep an eye if somebody is joining, so admit them, right? Because we might be busy somewhere else, so probably you can do this. Thank you.
Yes.
The second, friends, as I always say, if we can all open our videos, we can interact better, so we can see smiling faces. Thank you so much. And thank you for joining, and look at the attendance. I mean, it's almost 168. We have touched in just 5 minutes, 168. I think this is something, because this judgment speaks volumes then. And we have read headlines, we have read numerous articles. I think many people have written articles, fantastic views, very good expert views. But let's first of all, let's do it like this. I'm going to make a small presentation. I'm going to give you what were the facts of the case, what exactly the court said, and then probably after I finish my presentation, maybe in around 25 to 30 minutes, maybe less than that, I'll try to do it as early as possible. I'll share my opinion, I'll share my views. Then we will have an open discussion, and we will have the views of all those people, because Mr. Panicker said those who have read the judgment, they might have certain views. In fact, I would say those who have not read it, they also have views, because we are all reading headlines in WhatsApp and still we are forming our views. But anyhow, we really need to understand what the facts of the case are, because there are 2-3 things which are very important from a legal perspective. Of course, as an IP, we have to be trained in legal areas also. Every judgment, my dear friends, must be seen in the light of the facts of that case. Of course, the principles will definitely apply. Whatever the ratio or the reasoning which has been given on propounding the law by this Honorable Supreme Court, that definitely applies. But certain facts turn on the facts of certain things really turn on the facts of the case. So therefore, I think we must read every judgment with a slight pinch of salt. So anyhow, let me share my presentation with you. It's a small presentation. And because I've produced certain parts, so it may look a little longer, but it is not that long. So just give me a moment. Let me try to share it. Yeah. Yes, now I can share it. Okay. So friends, we are talking about the Bhushan's case, which is Bhushan Steel and Power Limited, which has been, this judgment has been typically rendered on the 2nd of May, right? And that is a very important judgment. Not only friends, may I request everyone to please keep themselves muted. We will have a discussion later on. In case you have some strong opinions also, you can put it in the chat box also. But plus first, hear me out. I think that's very important. The facts of the case are extremely crucial in this case. So the name of the judgment is Kalyani Transco, because this became the lead case. There were typically 8 appeals before the Supreme Court. And this became the lead case, Kalyani Transco versus Bhushan Power and Steel Limited. Now, friends, Let us understand the facts of the case. Number one, this case is one of the dirty dozen cases, as we are all aware and as we call, which were recommended by RBI to be referred to insolvency to the NCLT. Now, this case against BPSL, I'll call that as BPSL, not Bhushan Power and Steel, was initiated by Punjab National Bank, and it was admitted by NCLT way back on 26th July 2017. So it was early days. And IRP invited claims on 28/7. So we know that the new public announcement is to be published within 3 days. So it was done in a timely manner. Financial creditors' claims, look at the figure, my dear friends, 47,204 crores. These were the claims which were admitted. And operational creditors' claims were admitted to be only to the extent of 621. In fact, that is also a large figure, but it pales into insignificance if we compare with the financial debts, 47,204 crores. So typically around 48,000 crores total. And now, when the plans were invited, three parties were the major contenders: JSW, which was the successful resolution applicant, and then we had Tata Steel, and then also Liberty House. They submitted their plans when the advertisement was published. At that time, there was no EUI kind of a thing because there were no system at that time. The IBBI had changed its regulation later on. But anyway, in 21/9/2017, that advertisement came. Pursuant to that, they submitted. And revised resolution plans were also submitted after negotiations. And there were some NCLT stipulated timelines were there. So we are not going into those details at the moment. Now, the Committee of Creditors, as per the records, they evaluated the plans, and JSW, which ranked highest plan on an evaluation matrix, but the facts of the case are which are stated in the judgment are that no formal declaration of H1 and H2 was made initially. This is one of the major points which, in fact, the Supreme Court has also relied upon by making its judgments and observations. And then JSW submitted a consolidated resolution plan on 3rd October 2018. And then they, of course, issued an addendum letter also on 10/10 after 7 days due to amendments in CIRP regulations. So we are aware that during that time, some CIRP regulations were amended. So they submitted some, other details along with that. And the JSW consolidated plan, naturally with the addendum, it was approved through e-voting. So e-voting continued for 2 days, 15/10/2018, 16/10/2018. This is a very important date because many things are turning on this. So please remember 16/10/2018 when the CoC approved it. Resolution professional was supposed to file that application for approval of plan with NCLT. Look at the date at what date he filed it, 14th February 2019. Now, from 16/10, when the approval of the CoC came, application was filed after 4 months, 14 to 2019. This is one area where Supreme Court has come down very heavily on the RP, that why you took 4 months to file this application, why it was not filed in time. So this is another lesson for the IPs, also for us, that we must do it in a time-bound manner. Then, of course, because we are aware that there were some CBI cases were there. So CBI registered an FIR on 5th April 2019, which was typically after the approval of the resolution plan against the BPSL directors. And various criminal charges were filed. And Enforcement Directorate also pursued some cases and filed money laundering cases against them. Now, because some issue is also coming with PMLA, so that is why this fact is also relevant to be stated. Then NCLT approved the JSW's plan on 5th September 2019, subject to certain specific conditions, including handling of criminal cases and distribution of the CRP profits. So we are not going into the details, but this is basic facts will work here. Then, because JSW, who was the successful resolution applicant, was not satisfied with the certain conditions which were imposed by NCLT. So therefore, they also filed an appeal. And along with that, some operational creditors, some other creditors also filed appeal, and they were also before the Supreme Court later on. So even JSW, who was the successful resolution applicant, they also filed an appeal. Now, that is one of the question where the Supreme Court has made observations, rather very scathing observations against NCLAT. They said, how come you could entertain such an appeal? We'll go into those details, but this is also one of the relevant facts. And then Enforcement Directorate had also attached the assets of BPSL, Bhushan Power, under PMLA on 10th October 2019, that is, which was after the CIRP date. And they were challenged, and this attachment was challenged before NCLAT. Now, this is something which is again where Supreme Court has come down very heavily on NCLAT, and they've laid down the law now that whether NCLAT can entertain an appeal or any application relating to attachment by the Enforcement Directorate. So this was there, but typically the attachment was stayed that during that time. And later on, we are all aware that Section 32A came. So therefore, this application by Enforcement Directorate was also withdrawn because they were, you see, aggrieved by the decision of NCLAT. So NCLAT approved the NCLT's decision on 17 February 2020. They also modified the certain conditions regarding the role of the monitoring agency. They also appointed a steering committee. All those, some changes were made in that. Suspension of the board, handling of the statutory liabilities, distribution of the CRP profits, and undecided claims. So they passed a lot of instructions. They modified certain decisions of NCLT. But the date is relevant, 17th February 2020. Now, naturally, some people were aggrieved by the NCLAT decision. So therefore, further appeals were filed before the Supreme Court. And they were filed somewhere in 2020, March 2020. And now we are in 2025. It took 5 years for the Supreme Court to come out with the final judgment. Now, look at this, my dear friends. The resolution plan was approved by the CoC on October 2018, which I just mentioned to you. Adjudicating authority approved it on 5th September 2019 and appellate tribunal on 17th October 2020. So 3 years, 2018, 2019, 2020. So these are the basic facts of the case. Now, the principles which I mentioned also earlier, they have to be borne in mind when we analyze critically any judgment is number one, case analysis are always peculiar facts of the case. So we have to read the case based on the facts. So that is why I mentioned certain facts. Legal compliance will override any economic argument. Now, this is something which is very, very principally one has to really understand, because I have read a few articles by very prominent persons that economically this judgment may not be viable. Well, with due respect, I have some different opinion, but of course, we will all share our views. And of course, emotions do not matter in, you see, legal matters, right? So let us look at the one of the important things. When this matter was taken up by the Supreme Court for the first time, some money was to be paid or had been paid by JSW to the Committee of Creditors. So now the question that arose is, supposing some people are successful in this appeal, supposing the resolution plan is shot down later on, what will happen to the money which has been paid by JSW, the SRA, to the Committee of Creditors or the others? So in that case, Dr. Abhishek Singhvi, who was appearing on behalf of the Committee of Creditors, he made a statement before the court, and it was recorded in the order on 6th March 2020, that in case the CoC members or anyone receives the money will be returned within 2 months if the appeal succeed. Now, so therefore, that case has now happened. So 2 months, now the CoC will have to refund money back to JSW. So JSW, whatever money they have paid, so probably they are saying that we have paid 19,000 crores, so maybe they will get their money back. That is one thing which is there. Now, what has been questioned by the Supreme Court in this judgment? Broadly, my dear friends, number one, role of NCLAT. Role of NCLT. There have been certain remarks on that also. Role of a resolution professional, I think on 4 or 5 aspects. There are serious issues, and I think we must learn lessons from that. Role of Committee of Creditors. Now, this is something which is very interesting, and I think this should have happened much earlier. Because all this while, I think we all have been under the impression that commercial wisdom, that became a buzzword. That no NCLT, no NCLAT, nobody can interfere into the commercial wisdom because this is the economic decisions which is to be taken. But the Supreme Court now lays down certain principles that even commercial wisdom must follow these guidelines. This is extremely important. So we will talk about that. And of course, the role of the successful resolution applicant, not role, I would say the conduct. In fact, they have, questioned the conduct of the successful resolution applicant, which is the JSW. So these are the areas. So every stakeholder who was involved, right? Except the promoters here. Rather, promoters have been successful because they challenged, they filed an appeal and they have been successful in setting aside this. Of course, they are not the beneficiaries because the company is in any case going into liquidation as per the Supreme Court order. Now, role of NCLAT, why it has been questioned very briefly. Of course, we'll look at certain paragraphs that directions have been issued without jurisdiction or authority of law. This is one of the things which the Supreme Court says. Do you know on what ground it has been said? That is typically that PMLA has attached, under PMLA, Enforcement Director has attached it. An application was filed before them. They set aside that attachment or they state that attachment. They say NCLAT did not have powers to do that. Now, every RP may be questioning it. Oh, then where do I go? What should I do? This will spoil the whole process of the IBC. In fact, there is a separate solution which is attached to it. We'll discuss it in a little while. Just let us understand this way. And they have acted beyond its powers, resulting in perverse and legally unsustainable judgment. That is also the Supreme Court has said. And not only on one ground, there are many other grounds. The role of NCLT, why they have criticized? Number one, they say the plan was non-compliant from day one, which was submitted by the SRA. Now, why did not the NCLT looked at section 30 subsection, not 31(2), in fact, it should be 30 subsection 2, and why did they approve without looking at the problems which were there, because it was typically non-compliant plan. So we'll look into those details, what were non-compliant. Role of RP, of course, on many grounds. Section 29A, not seen by RP. Section 12A, Section 12, extension not followed. Section 30, subsection 2, non-compliant resolution plan put up before the CoC and also before the adjudicating authority. These are certain aspects and non-filing of avoidance transaction. In fact, 4 points have been raised by the Supreme Court against the resolution. So this is something which is very crucial for all of us. It's a very great learning lesson for all of us. And of course, the role of committee of creditors. And if you ask me personally, I'm very happy to see these kind of statements there, that they did not appropriately exercise commercial wisdom. They approved a resolution plan contrary to the mandatory provision of the code. So now today, my dear friends, besides the RP, the onus has also now come on to the committee of creditors that look, in your commercial wisdom domain, it is not simply the economics or the financial figures you are going to see it. You must see whether the plan is also compliant or not. This is something which is extremely crucial now. So now the hands of RPs are strengthened. In fact, I'm very happy to see this. And then they also say that committee of creditors, they took contrary positions before the court. What contrary provisions? Briefly, I'll explain. Of course, I've got one or two slides on this. Initially, when JSW was not implementing the plan after the approval of the plan, and they said, look, because the appeal before the NCLAT is pending, so therefore we are not implementing. They have reproduced an order of NCLAT which says that implementation can be done. But still it was not being done. So it was a delay which was happening. And the Supreme Court was not very happy with this kind of a thing. And at one moment, an affidavit has been filed on behalf of the Committee of Creditors, heavily criticizing JSW and saying they're undermining IBC, they are not doing it, they are doing everything against IBC's objectives. And suddenly, after 1 month or 2 months, when the things changed, they accepted that same amount from JSW and they said, we are happy with this. So Supreme Court has come down very heavily. This is what happened. On one day you were criticizing them, and then you have contrarily now undermined the interest of the creditors, and you have taken absolutely, reverse position. So that is also one of the things. and accepted payments from JSW without raising objections. So this is also one of the things which is there. And of course, as far as SRA is concerned, Supreme Court has made very scathing remarks. Today we are feeling, oh, a plan has been disapproved. But my dear friends, if a plan which is the basis of a fraud, I think Mr. Patwardhan and we were discussing the last IPNet webinar, and he pointed out a very important paragraph where it is clearly mentioned that JSW played a fraud upon the court. It played a fraud with the CoC also. So a plan which has been approved on the basis of fraud, can it sustain, my dear friends? The answer is no. And therefore, number one, that is also situation. Secondly, they are saying they have willfully violated and did not comply with the terms of the plan for nearly 2 years. It was kept in a cold storage, not being implemented. And then they submitted a revised consolidated plan under the pretext of regulatory compliance. They said, look, if they were given the chance to submit a revised plan, why this chance was not given to the other two SRAs? Now that is coming into question. So friends, when we are working, we are as an RP, we must see that we are fair to each and every SRA. So this is not that we will give one opportunity to one SRA only to modify the plan and others will not be given. So this is also one of the important things, right? Now look at the few of the statements which have been made. So appeals by the JSW before NCLAT. I think this was one of the important aspects. Look at this. Words which have been used. I've reproduced the exact words. Supreme Court says, interestingly, the NCLAT-wide impugned judgment dated 17th February 2020 not only entertained, but also allowed the said appeal of JSW, which was not legally maintainable. Number one. Number two, it modified the conditions which were not suitable to JSW and dismissed all other appeals filed by the operational creditors, ex-promoters, and state of Odisha. So they are coming down very heavily that, look, number one, JSW had no right because they have gone into section 61. They say appeal can be filed only under these circumstances, not any other things. And only an aggrieved person can do it. He says the person whose plan has been approved, how can that person be aggrieved? So therefore, NCLAT never had the authority to entertain that appeal. So they have entertained that appeal in a wrong situation. So this is something which is a great lesson for NCLAT and also NCLT that look, whenever you are doing, you must act under your domain itself. Don't go beyond your domain authority. And look at this. NCLAT also gave directions in para 147 of the impugned judgment, because I told you that certain terms and conditions were modified of NCLT with regard to an issue which was neither the subject matter before NCLT. Now there are certain things which they also changed or put in which were not before them in an appeal also. In the application filed by the resolution professional, nor the subject matter of the company appeal. They say if it is not the issue, how can you modify that condition? How can you put in those kind of things? So you have exceeded your authority. In fact, that is a lesson for them. And now look at this word which they have used. In fact, they have used very strong words. We fail to understand as to how the directions such as declassifying the corporate debtor company as a promoter of any other company or entity could have been given by NCLAT in the appeal filed by JSW under section 61, which was filed challenging only the conditions imposed by NCLT while approving the resolution plan. They said they only challenge the conditions, that's all. But you also entered into a domain which was never there. Now, let me explain you what was the issue here. The issue was that this Bhushan Steel and Power had certain subsidiary companies or joint venture companies. Now, this Bhushan Steel and Power was treated as promoter of those. So NCLAT said that once the JSW comes into picture and they substitute Bhushan Steel, now they will not be classified or categorized as promoters. Now, this is something which the Supreme Court says that this was not their authority, neither asked for, and you should not have entered into the domain. And look at the next words which have been used. I mean, can Supreme Court use harsher words than this on another authority? Look at the words which they have used. The first sentence, we are also stunned by the observations made and findings recorded by the NCLAT in the paragraphs 51 to 57 of the impugned judgment, whereby NCLAT has virtually justified the non-disclosure and suppression of the matter of fact in resolution plan made by JSW with regard to joint venture agreement in the matter of joint allocation of so and so coal block. So friends, what happened? One coal block where application was made and it was allotted to a joint venture. And do you know who were the partners, joint venture partners? JSW along with BSPL, Bhushan Steel and Power, they were together in that joint venture. And they had you see, made an application to the state of Odisha and they got those mining rights. Now, this means JSW was a related party in terms of section 29A of BSPL. Did they disclose this fact to the RP? Did they disclose this fact in an affidavit? They said they did not. They in fact hid that. And when it also was brought to the notice of NCLAT, NCLAT just put a mud on this. This was one portion where the Supreme Court has come down very heavily. And secondly, and in fact, on this aspect, even RP has also been grilled. I'll tell you what have been the observations. Now, other things, these facts suppressed by JSW in its resolution plan surfaced during the course of investigation in PMLA proceedings initiated against the CD and others. Based on the said matter, an issue was raised before NCLAT whether JSW was a related party and therefore ineligible under Section 29A. Now, some people may say, oh, it was found out only in the course of investigation by PMLA. Well, that is all right, my dear friends. But allocation of any mining right is also in a public domain. Is it not the duty of the RP to do due diligence on this issue? Supposing JSW does not disclose, naturally, an SRA may not disclose all the things. So that means we will not go into the details. So this is something which is important and I'll come to that in a little while. So let's look at this. So NCLAT in the impugned judgment has sought to justify the suppression of the facts made by the JSW. And Supreme Court also played it little lightly. They said, since the related party issue has not been pressed in the argument, so we are leaving it, we are not stretching it so far. But they made very scathing remarks. And in fact, the words which are used, we are stunned. I mean, I have never seen these kind of words being used in a Supreme Court judgment. Now, friends, as far as the power of the NCLAT is concerned, I think we all should now be aware of this. And what course has to be taken, we can also discuss. Whether the NCLAT has any powers of judicial review over the decisions taken by the statutory authority under the PMLA. Because PMLA is a statutory authority, they are taking certain decisions. Can you go to the NCLAT or NCLT for judicial review of the decision taken by any authority? Supreme Court says no. So friends, please remember, if there is any attachment of the assets or any order which is being passed, now NCLT and NCLAT, they do not have powers. Look at this. And in fact, they are not saying they are also on the basis of the earlier judgment of the Supreme Court. Neither the NCLT nor NCLAT is vested with the power of judicial review over the decisions taken by government or statutory authority in relation to a matter which is in the realm of a public law. So they say PMLA is a public law, cannot be brought within the fold of the phrase arising out of or in relation to insolvency resolution appearing in 65C of IBC. So what is the proper course? If any authority has passed an order for attachment, approach that authority now, ask for that, look, since the company is in CRP, there is a moratorium, please lift the attachment. If they do not do that, then approach the appellate authority of that authority under that law. So NCLT and NCLAT are out. In fact, friends, we also face this where the DRAT had appointed a receiver in one of the cases. So the question which came before us was, that was way back in 2018, that whether we should approach NCLT, whether we should approach DRAT, that means the authority higher than the authority which has appointed, or we should approach the High Court in a writ petition. So when I had to take a call, I said NCLT does not have power. So I approached the same authority which had appointed, DRAT had appointed. So we approached DRAT. We requested. We said, look, and the law was new. We explained that whole law, but ultimately that our application was rejected because on a certain ground that, look, in moratorium, I can't even pass that order. So that was one of the grounds on which our application was rejected. Then we filed a writ petition before Delhi High Court. And this is the case, the name of the case is Amira Pure Foods. And that's a landmark judgment where the High Court said DRAT was not powerless to pass that kind of a relief to give relief to these under in CIRP. So therefore, friends, the best approach is do not approach NCLT or NCLAT. Go to that authority or the authority above that authority, that means an appellate, or approach the High Court in a writ petition. This is the proper course which you have to do. The PMLA being a public law, NCLAT did not have any power or jurisdiction to review the decision of the statutory authority under the PMLA, right? And in fact, the strong words which have been used is that NCLAT were quorum non judice. Quorum non judice means they had no jurisdiction over this particular case. So I think these are landmark judgments, and I think we should be aware of that. Now, role of RP has been challenged on 4 grounds. Friends, we will take questions and discussions later on. Let me finish it quickly. In the meantime, if you want to put it in the chat box so that you also remember, and then we all get the benefit. Okay. Now, role of RP, as I mentioned, on 4 grounds: Section 29A, Section 12, Section 30, subsection 2, and of non-filing of avoidance transactions. 4 grounds have been put up against the RP's role. The RP's role has come under question. Now, here, simply they are saying that, look, an affidavit is required to be filed by an SRA that is a compliant. Now, the question that arises is, which everyone, in fact, most of the RPs are still following that, which is not the correct procedure. That you take an affidavit and you believe it. No, you have to conduct your own due diligence. And then you have to give a certificate that, yes, I have looked into this and 29A is complied with. So here the Supreme Court observes there was neither the certificate given nor any statement was made by the RP in the said application to the effect that the contents of the affidavit filed by the RA with regard to its eligibility were in order. So friends, how will you give a certificate unless you do your own check, unless you do your own due diligence? So this is extremely important, and Supreme Court says RP failed to do that. So 29A was not checked. Had he checked it, probably their relationship with BSPL could have been come to the light. The eligibility, ineligibility, look at this, what they are saying, of the RA goes to the root of the matter. It was incumbent on the part of the RP to verify and certify that the contents of the mandatory affidavit were in order. So they are simply clearly saying in you can say unambiguous words that this is the duty of the RP to see. So we are not simply going to rely on the affidavit of the this thing. So now, my dear friends, what happened after that? The RP also made certain submissions that you see that we checked it because there was an affidavit filed. So Supreme Court said nothing doing. Now, the second part was on Section 12. The Supreme Court says the main object for enacting IBC is to complete the entire CIRP in a time-bound manner. I'm very happy to see this, friends, because we are all affected by the non-compliance of the time. And I remember now BLRC, speed is the essence. And that is the reason a timeline is set out in the code and its regulations for every stage of the proceeding. In fact, I must also point out here that they have defended the IBBI also. They say the regulations which have been framed by IBBI are also a part of the legislative exercise because it comes under delegated legislation. There are timelines which are there. They are statutorily bound. Everyone is statutorily bound by that. So I think IBBI should be very happy to hear that, because many benches were typically saying it is directory and all that, but here the Supreme Court says it is mandatory. And they say the time is the crucial factor of the scheme under IBC to allow the proceedings to lapse into indefinite delay and will frustrate the very object of the code. Now here, what has happened? The problem where it has been there is, as I showed you the entire thing, so it went beyond 270 days. At that time, it was 270 days and not 330 days. Then the question here arises is, even the plan was also filed beyond 270 days. Should the RP filed an application for extension for the time period or not? The answer is yes, he should have done it. Here, there was no application filed. In fact, no CoC meeting was held to get the extension approved. So therefore, Supreme Court has come down heavily that there is a non-compliance of Section 12. And what they are saying, it is explicitly made clear. Now, this is the word which has been used. It is explicitly made clear that the provision contained in Section 12(1) is mandatory in nature, as the expression shall be completed is used in that particular section. So they are making it absolutely abundantly clear that everyone is supposed to follow the timeline. I'm so happy to see this. In fact, this should have come much earlier, but whenever it comes, I think it is always better. Thus, the process which was required to be completed within a maximum period of 270 days from 26 July 2017, the resolution plan of JSW was sought to be placed before the NCLT for approval under Section 31 after almost 1.5 years on 14th February 2019. They say not 270. You have filed it after 1.5 years, after maybe more than 480 days. Where is the extension? Why you did not apply? And why this angle was also not looked at by NCLT? So if a plan which is approved after the time has lapsed and it comes to NCLT, will NCLT ignore it? In fact, on this ground, they have also passed very scathing comments on NCLT also. But anyhow, friends, this is very important for RPs. It is incumbent on the part of the RP to bring to the notice of the CoC about the expiry of 180 days and seek instructions in regard from CoC. However, no such application appears to have been filed by the RP, nor any order extending that time appears to have been passed by the NCLT. They say, of course, RP is at fault. But what did the NCLT do? Why did they consider a plan which was beyond the time limit, mandatory time limit? So this is what they have typically mentioned. In fact, here also they are saying that e-voting was concluded on 16/10 and application under Section 31 for approval of the plan was filed by the RP on 14/2/2019 after 4 months. He said, why there was a delay of 4 months? That has also been questioned. So I think RP's conduct has been questioned, you see, in a greater manner in this particular case, right? So therefore, this is one of the important things. So anyhow, let us look at this. Yeah, there is no justification whatsoever submitted by the RP because they questioned it. So RP said, oh, there was an appeal which was pending before the NCLAT. So therefore, I could not file the plan and something like that. But if you look at the next paragraph, right, in that paragraph, they say that the NCLAT has given an order that you can go ahead with the UC plan also. So in fact, those permissions were also there. So NCLT, here they are now talking about the role of NCLT. In that view of the matter, we have no hesitation in holding that the application submitted by RP seeking approval of the resolution plan under 31 being hit by Section 12 of the IBC, NCLT has committed grave error of law in approving the said plan void its order dated 5/9/2019. It is given in para 57. Now look at this. Not only RP, even NCLT has been found fault with. So this is a serious concern. The role of the RP while conducting the entire CRP, and this is a very important word which we must bear in mind. This is a new thing which has come up. RP is not only an administrator or facilitator, but also is an invigilator. You are like a monitor. You have to monitor everyone's move to ensure that CIRP proceedings are completed in a time-bound manner for maximizing the value of assets in order to balance the interest and ensuring that there is a compliance of all mandatory provisions of the code during the course of the proceedings. So I think, friends, if RP in this case has not done something, I don't think anyone will be able to defend that person. The mandates given in the said regulations to carry out the provisions of the code have to be strictly complied with by all the stakeholders as well as by the authorities under the code. So now they are passing a judgment saying all stakeholders, including NCLT and NCLAT, they must actually look into this and they must follow the law. The RP has utterly failed in discharging his duties by not making an application in time under Section 12, by not certifying whether RA was an eligible under Section 29A. He has also failed to make any applications for avoidance of transactions. And lastly, RP has also failed to confirm whether the resolution plan of JSW met with the requirement under Section 30, subsection 2. Of course, with regard to some payments to the operational creditor. So four grounds, RP has been found fault with. Despite such gross non-compliances, so Supreme Court is terming them as gross non-compliances of mandatory provisions, the RP placed the resolution plan of JSW before the CoC. And the CoC, now look at the role of the CoC. CoC also, without verifying the mandatory requirements of Regulation 38, particularly with regard to feasibility and viability of the plan and effective implementation of the plan, and capability of RA to implement the plan, permitted the RA to submit consolidated resolution plan with addendum letter. This is one. CoC also did not discharge its duties to carefully examine the feasibility and viability of the plan and the capacity and resources of the applicant JSW for implementation of the plan proposed by it. Now look at this. A very strange procedure was followed by the CoC. As recorded in the minutes of 18th meeting held on 14th August 2018, RA had acquired highest score amongst the three prospective resolution applicants, but there was no declaration made as to H1 and H2. Who is H1 and H2? They did not do that. Despite such gross violations of mandatory provisions of IBC and CRP regulations, or the entire proceedings by the CoC, while considering the consolidated resolution plan and addendum letter, RP, without paying any heed to the said violation or non-compliance, submitted the said plan for approval before the NCLT. So even the feasibility not checked by the CoC, now it is now boomeranging on the RP itself. They say, all right, how come you did that? So in spite of such allegations made and grievances raised by CoC on affidavit before this court, surprisingly, the CoC, for reasons best known to it, all of a sudden changed its stand and accepted 19,350 crores at a very belated stage offered by JSW without any demur. So first I told you that they filed an affidavit. Later on, they accepted the plan. The changing stance. So Supreme Court was very perturbed by the changing stance of the CoC. They said the changing stance of the CoC in the present proceeding also smacks of its bona fides and raises serious doubts about the exercise of its so-called commercial wisdom. So they are challenging at the root of the bottom of the thing that commercial wisdom was never checked in. Now look at this. This is a very important statement, friends, which is going to change the whole course. Commercial wisdom of CoC means a considered decision taken by the CoC with reference to the commercial interest, the interest of revival of the CD and maximization. The wisdom is not a matter of rhetoric, but is denoting a well-considered decision by the CoC as the protagonist of the CIRP. So friends, the point the Supreme Court is saying is that it is the utmost responsibility of the CoC because the faith is, the trust is on them. So they must look at this. And they say if commercial wisdom merely does not mean only financial decision to be taken, oh, we are approving the plan. He said, no, you must see whether compliance has been done or not, whether 29A has been checked or not. So it is also your duty to do that. If the resolution plan, look at this, they have explained it. If the resolution plan does not comply with such mandatory requirement and such plan is approved by the CoC, it could not be said that the CoC has exercised its commercial wisdom while approving such resolution plan. So friends, let us stop equating commercial wisdom with only the financial decision or simply approval of the plan. No, it can be questioned if they are approving a plan which does not comply with the mandatory requirements given in Section 32 and Regulations 38 and 39. Role of CoC, again, they say, contrary stance taken by CoC at various stages of proceedings clearly proves that CoC has played foul and had not exercised its commercial wisdom in the interest of creditors. I've skipped certain paragraphs which were there in the judgment, friends. They looked at the minutes, and in one of the minutes it has been recorded, 10-15 points were recorded that 29A is to be checked, this is to be done, this is not done, this is not good in the resolution plan. All of those things are there. But then suddenly the plan has been approved without even any discussion whether these things were corrected or not. So I think looking at that, the Supreme Court is coming down very heavily. NCLT also, without satisfying itself whether the RA was eligible to submit the plan or not, whether the application for approval of plan was within the prescribed time limit or not, whether the RP, whether the resolution plan submitted by JSW had met the requirements of Section 32 or not, and whether the resolution plan had the provisions for effective implementation, they approved the plan. So even on NCLT, they are coming out now very heavily. So first RP, then comes the duty of the CoC. Even assuming the CoC also does not do that, then NCLT was supposed to look into all these things. So NCLT has also not done it, right? So they should have insisted that, look, why you have not, why you relied only on the affidavit, why you have not done your own due diligence. And now coming to the SRA, the last stakeholder who was there, the conduct of JSW demonstrated ill intent and malafide to mislead the court and misuse the process of the court in order to delay and defer the implementation, which was in fact an unconditional plan. Now, friends, I have seen many articles. Everyone is defending JSW. Oh, they put in so much of money. They paid 18,000 crore. They did everything. They did right for the company. But do you know they misled the court? Do you know that they did not implement the plan for so much of time? This is what the Supreme Court says, and they have written the word. There was a willful breach of the plan by not implementing the same. And they say pendency of the appeal or any litigation does not mean a stay, and binding resolution plan has to be done. And by its action, it is bleeding dry the public sector banks to whom it owes 19,350 crores. They say if you, and in fact, this is one of the important aspects in one of this thing. They presented a very rosy picture. At the planet, they say, we are making upfront payment. This is what Mr. Padwardhan also pointed out that time. Why they were treated, why this plan was approved, typically because they said, we are going to make upfront payments. So naturally, the person who makes upfront payment, their plan is taken, is approved in the sense that it is more beneficial to the creditors, isn't it? So having done that, they say, if you don't implement later on, that means you are playing a fraud. So first you become a successful bidder because of that reason, and then you don't implement for such a long time. And then you amend the plans also. See the upfront payment and the commitment. This is the paragraph, my dear friends, para 80. The upfront payments and commitments with regard to infusion of equity into the company was one of the main criteria on which JSW had scored the highest in the evaluation matrix determined by the CoC. Thus, after obtaining the approval of the resolution plan from CoC, by presenting a rosy picture, misguiding the CoC, and defeating the rights of the other RAs, JSW did not respect and honor the said commitments, and on the contrary, tried its level best to delay the implementation of the plan without any cogent reason or justification. This is nothing but a misuse of the process of law and a fraud committed by JSW with the CoC and other stakeholders. Look at this, my dear friends. Let us not try to defend any SRA. This IBC is not a battleground, or it's not a playground to play fraud. I think we should learn lessons. In fact, Supreme Court has done absolutely right, because we don't want manipulative SRAs to come in. We want honest players, sincere players to be there. So I think this will clear out the base now. It will not discourage, because there have been a lot of questions. Oh, this will discourage the SRAs now to come, RAs to come. I don't think so, sir. I think the honest RAs will be very well benefited now. And then there was an argument, like most of us are under the impression, oh, sir, the plan has been implemented, let it be approved. Do you know what the Supreme Court says? Supreme Court has termed it as fait accompli. It says any illegality of any nature cannot be permitted to be perpetuated, and a plea of fait accompli cannot be permitted to be raised by any party to cover up their illegal acts after achieving the ill-motivated intentions circumventing the law. They say, we don't care whether the plan has been implemented or not. We are going to reverse it because there has been a fraud, there has been illegalities, there has been a cover-up. Thus, it is quite clear that merely because the code is silent with regard to phase of implementation of the resolution plan by the SRA, neither the tribunal nor the court should give excessive leeway to the SRA to act in flagrant violation of the terms of the resolution plan or in a lackadaisical manner. So friends, this is something which has been very, very crucial. I think we need to really understand. The economics is fine, friends. We are all there to that the company must survive, the company must be a going concern. That is all right. But if it is not, let it send, let the company go in a timely liquidation manner to the liquidation. Let's do that. That is also the purpose of IBC. So it may be noted that any contravention of the terms of the approved resolution plan by any person on whom such plan is binding is liable to be prosecuted and punished under Section 74. In fact, this is a hint to IBBI and MCA that you must file a Section 74 prosecution against this SRA JSW now. Serious repercussions, my dear friends. Okay, so let's conclude, my dear friends. Resolution professional failures. He did not comply with statutory duties, Section 12, Section 32, Section 29A, non-filing of avoidance applications. Committee of creditors, they did not exercise their commercial wisdom because they approved a non-compliant plan. This is what the Supreme Court says. And you are there to protect the creditors' interest, not your interest, but all creditors, all stakeholders. They say you did not do that. JSW's non-compliance, I think we have already seen that. They were declared as the highest bidder, but they did not comply with the plan, approved plan for about 2 years, undermining the purpose of IBC and invalidating the CIRP process. This is exactly what the Supreme Court has been very harsh about. Resolution plan non-conformance, because they simply say it should have been outrightly rejected by NCLT. So they have come down heavily on NCLT also. And NCLAT also, I have already mentioned those two grounds which are there on NCLAT that look, number one, they should not have entertained the appeal of JSW. And two, they should not have gone into the detail of the under PMLA. So they should not have done that. And of course, they also modified a lot of conditions which were not part of the appeal. So that is also things which have been taken care of. So final comments, friends. Does it reinforces the credibility of the resolution process? The answer is yes. Let's not be worried. I'm not worried about the IBC ecosystem here. I'm very happy to see such kind of a judgment. The sanctity of the procedures under IBC, that must be maintained. And that typically strengthens the trust in the process. If the trust is not there, if manipulations are there, do you know the IBC will be successful? Do you think that? The answer is no. So fairness is very, very important. And similarly, accountability of all key stakeholders. So now who has come into the limelight? Who are the pillars? As we say, RPs, CoCs, SRA, and of course the adjudicating authority and the appellate authorities. Now they must withstand judicial scrutiny. I think this was somewhere down the line which was coming. It has already come now. So it will now encourage better diligence, better transparency, and adherence to the statutory timelines and procedures. I think this is something very, very important. And in fact, it restores faith in the judicial oversight. Because otherwise, what will happen is simply we say, oh, after 5 years, Supreme Court has done that. So, my dear friends, legal system takes that time. But in 2020, an undertaking was given on behalf of the CoC that whatever money we receive, we'll give it back to you. So they also were aware of this fact that this plan could, be turned down. So therefore, once this has happened today, I think we should not criticize Supreme Court. Of course, those are systemic issues. Whether the delays are there, we are seeing those delays at the level of NCLT and NCLAT also. So those kind of things will definitely be there. But here we are getting a message that judiciary is serving as a vigilant guardian for procedural abuses also. So procedural abuse is also very important, and it also discourages manipulative or opportunistic behaviors. You can't really bulldoze your, way into this that, look, I have submitted a plan, I'm a big player, it must be approved. No, that cannot happen, my dear friends. So therefore, ultimately, no shortcuts, safeguard the interest of the stakeholders. That is very important. And long-term economic stability, it is good for that. Because today, what we want a predictable this thing framework. We want a transparent framework. We want a fair, framework, isn't it? So if that kind of a system is there, everyone will have good confidence and trust, and naturally it will involve you see economic growth. So according to me, it does not affect the economic stability at all. Rather, it is coming into this that look, it is better that this judgment has come, and a lot of ambiguities and uncertainties and focus on the timelines which has come back. I think it will reduce the future litigation and delays to a larger extent, because this is extremely crucial, my dear friends. Okay, so I think I'll just stop here, and we can have a discussion on this. But before we have that, let us also understand two, three things. The first lesson which we learn is that we must play by the rules. Number two, courts should not shy away from stepping in, because this is actually a safety net. Three, most of the critics typically are saying that this creates economic uncertainty by disrupting a plan which was already in motion, which was already being done. But friends, according to me, fixing the problem now, even if it is late in the day, it is better than letting it grow bigger. This is what very important thing is there. And in one of the articles in Supreme Court, I was reading, my lords, it was, the heading was, my lords, not the not the process, but the outcome. That means outcome is more important than the process. This is what the typical meaning of this thing. Well, friends, I really beg to differ from them. A good outcome, can it rest on a shaky foundation? The answer is no. If the steps which are leading to the resolution are biased, if they are flawed, they are legally weak, well, the result will have to be questioned, isn't it? So therefore, if that resolution plan fails to meet that standard, then these courts have to step in, my dear friends. And the legal clarity today which we have, it makes the IBC more dependable. And I think the IBC becomes more welcoming for the genuine and serious players. So we must keep the opportunistic players out. And this particular judgment or ruling, it typically protects the process and reassures the investors that IBC is not a playground for manipulation. So we must value transparency, fairness, and typically predictability. So therefore, friends, according to me, that's my personal opinion, and we'll have some discussion today. I think it will evolve into a robust, fair, and credible network. And if we insist on high standards, I think the flawed resolutions will not manipulate the whole thing. So according to me, friends, my opinion is very simple, that it makes the IBC ecosystem stronger than ever before. One company fails, doesn't matter. Many other companies will come. It's a steel plant. Somebody will take it. In liquidation also, it can be sold as a going concern. And mark my words, if it is sold as a going concern today, it will fetch even more than 19,000 crores. So there is no loss to the company, not to the JSW also. JSW, whatever money has been paid, CoC has already given an affidavit, they'll return the money. What else is required? So I think these are very important aspects. So let me stop here. I've taken a lot of time to explain in detail. So let's hear from the others. Mr. Panicker, can you take over from here now?
Yeah, thank you, Dr. Makhija. I think you have gone in depth into this parawise observation of Honorable Supreme Court. Well, at some point of time, this ought to have happened. I was looking for that. My only worry is probably this got significance because this could reach up to Supreme Court. And small cases like this would have gone, nobody knows, under the pretext of commercial wisdom, and it would have gone. So there are few questions in the chat box. I'll just read first, and if time permits, we'll take discussion. Otherwise, I think preference should be given to the members.
Sure. Go ahead, sir.
First question is from Mr. Srinivasa Gudla. I think it's not related to this matter, but then since he has taken pain to chat down, so I'll just read that. Payment against operational creditors claim as per resolution plan approved was made by the RP. However, the SRA has failed to implement the plan. Honorable NCLT has approved the liquidation. Can the OC, whose claim was settled during the CIRP, file the claim before the liquidator? That is the question.
Okay, I think the answer is simple. now since the liquidation has been directed now, the matter in fact has been given back to the NCLT to pass a liquidation order. Of course, Supreme Court has said it is to be liquidated. We are exercising our power under Article 142 also, but they say we are sending it back to the NCLT for appropriate order. So naturally, the order will be passed by NCLT. So once the company comes into liquidation, friends, now whatever money has been paid to the creditors, now that is should return come back to the coffers of the company itself, isn't it? In fact, whatever money has been taken by the operational creditors, it should not come to the company, it should go to the resolution applicant because it came out of his pocket, isn't it? Now, as far as the claims are concerned, because they will have to return the money to the SRA, so therefore they can file a claim in the liquidation. That is what the reason is, right? Okay. So anyone, whether financial, whether operational, whosoever has taken the money, now they are under an obligation to return it to the SRA. So once they do that, then the liquidator can entertain the claims. Yes, sir.
But sir, here the difference is the RP has paid the claim. I mean, that is a very different case altogether. The question here is
No, sir.
payment.
Let me explain, sir. RP was here because RP was not acting as an RP here. Please understand it. The CRP process was over. The plan was under implementation. RP was acting as a monitoring professional. So typically he is wearing a different hat. So he was acting on behalf of the SRA only, isn't it? So money came from SRA and money was paid. He will not pay out of his own pocket. So therefore, they have to return it back to the SRA only. Okay.
So,
Yes.
Mr. Ravindra Belayur is as the second question. Collusion is equal to fraud. Any contract in which a fraud exists becomes null and void ab initio, goes back to the basics of contract acts. To my understanding, I have reservation about Supreme Court taking 5 years for this decision, unlike the judgments of Supreme Court in the first phase of IBC implementation. I think Dr. Makhija has clearly mentioned that.
Well,
Uh,
I'll just add one more comment, sir, because you are also a lawyer, and I think many lawyers are there. Typically, what happens is this was not an easy case. In fact, the if you read the opening paragraphs, the Supreme Court says there was a voluminous piece of papers. Maybe 20,000 papers were submitted in kind the form of an appeal and everything. So to read that, to get to this judgment, I think it takes time. In fact, the normal timeline for any appeal which is filed before the Supreme Court is not less than 3 to 4 years to 5 years. It doesn't see the light of the day, the final argument. Well, the stays and other things can be granted, but it typically takes that much of time, right? Yes, you are right. In the initial stages, there was some interest. There was a typical bench of Justice Nariman who was looking into it. But yes, the delays are there. We agree with that, sir. Okay.
Another important question, according to me, sir. In case of attachment, this is by Neeraj Agarwal.
Right.
Neeraj sir says, in case of attachment by GST authorities, what should be the relevant forum?
Okay. See, the answer is very simple. As far as GST authorities are concerned, now what should have you done? Supposing the case was not before the NCLT, tell me what you should have done. Think like that. Supposing the case was not before NCLT, it was a normal case of companies running, GST has attached it. Where will you go? Follow the same process. So don't think that NCLT is the solution for everything. So think like the MD of the company and go where the whatever the GST Act provides, there must be some remedy. So go to that remedy, go there and file that application there. Okay.
In case you are confused, approach Honorable High Court under 226.
Right petition can always be filed if there is no remedy available. Yes, you are right.
Mr. Neeraj Kumar, suppose municipal corporation has sealed the factory due to non-payment of property tax. In this case, I have to approach to their authority on NCLT. Just now you have answered, sir.
Correct. Correct. Same. See, first, my answer is very simple. First, you approach that same GST authority or municipal authority or same authority. Tell them that look, the company is under CIRP. There is a moratorium. Please withdraw your order. If they don't do it, then approach their appellate authority. There are always the remedies which are available in appeals. So whatever the appellate authority is, right? Like in municipal corporation, Probably, I think the finance secretary of that state probably has got some powers to look into those orders. So just look at those, approach them. If nothing is there, approach the High Court in a writ petition.
In fact,
Okay.
I'll add one here, sir. In fact, when it comes to liquidation, the liquidator is supposed to get a prior approval of NCLT before approaching any board, any
Correct.
judicial. What
Correct.
happened, learning from this particular judgment is that, especially when this PMLA thing, what we see in NCLT is most of the cases they'll approach NCLT for lifting the attachment. Now, this particular judgment will give evolve a separate jurisdiction jurisprudence wherein appropriate authority should be that. And the question is whether we should seek a first try before NCLT or not. But then
Correct.
look at the Supreme Court judgment here. I think we have to go and approach the appropriate authority.
Correct. Correct.
Next question is about the delay part of it. So it's from Vikram Kumar. What about the delay caused by judiciary? Supreme Court has not said anything in this regard. BSPL matter was disposed of by Supreme 5 years. Better late than never.
I think as far as Supreme Court is concerned, yes, sir, I do not deny that there was a delay. They should not have been delayed. Now the question is, there are delays at the end of NCLT and NCLAT. What is going to happen to that? In fact, there has to be, in fact, I mentioned in the last webinar also, when we discussed very briefly, I said, I'm waiting for that judgment to come also someday. When Supreme Court will come down very heavily on these, that why you are delaying these matters of approval of plans, of admission, and so many other things which are there. So I think we will have to wait for that period. But yes, Indian legal system typically sometimes delays, but that does not mean that we can ignore frauds. So that should not be the criteria. Emotions cannot work, sir. Right? Okay. Yeah, Mr. Panicker. Yes, sir.
I think the next question doesn't have much of a fact, but then I'm just reading. If I file plan after 270 days in 2025, this will affect after considering this judgment.
No, sir. Neeraj, the point is this, let's understand broadly. You can file a plan after 270 days, provided you have taken extension under Section 12.
Exactly.
Please remember this. If you have not approached NCLT, not approached CoC, and not taken an extension, then filing an application after the period is over can cause a problem. So if you are, supposing you are delayed by say 7 days, 10 days, file an application for condonation of delay. That's my suggestion is, okay?
The next question, Yuvraj Tiwari has answered in the lines which you have mentioned, sir. So I'm not answering. I'm taking.
Okay. Yes, absolutely right. I think Yuvrajji has understood it properly. Okay.
Kumar again. And after the order of Supreme Court, who will take control of BSPL before a liquidator is appointed?
Well, at the end, right now, monitoring agent is there, so he's in control. So naturally, he will continue to be in control. Liquidation order, we believe it will be passed in just 2, 3, 4 days, not longer. So it's a gap of only 7 days. So it's that 7 days, the person who is already in charge, he can't just leave that charge. So he will hand over the charge to the whosoever is appointed as liquidator. Okay.
Especially so when it comes to an order from Supreme Court, NCLT will quickly act.
Yeah, absolutely.
Ravindra Belur again. To my understanding, adjudicating authority has the power to put a company into liquidation if there is no plan received or approved within 180 days or 270 days. But unfortunately, AAs take more than 20 months to pass liquidation orders with CoC approved. This should change. It's just an opinion. We all will agree with that.
Correct, sir. We all agree.
Yuvraj Tiwari, again, also let us know how payment made by GST will get reversed.
Yuvrajji, I think I've already mentioned number one, there was an undertaking given on behalf of the CoC. So any CoC member, financial creditors typically have taken more money. So they will return the money to JSW. Now, as far as payment which has gone to the operational creditors, yes, there is an ambiguity, there is a difficulty. But at the end of the day, I look at this judgment that everyone will have to refund the money, including the operational creditors. So whether it will come or not, whether it will come in trickles, well, that's something which is practical, but everyone has to pay it back. And then they will have to file a claim before the liquidator.
Especially so when it comes from Supreme Court under Article 140, which itself is a law. If somebody, they will hear the music. As simple as that.
I think I can also anticipate another situation. Assuming Supposing you are not able to trace 20 operational creditors and they were paid 10 CR. Now, since JSW has paid to them, JSW will step into their shoes and JSW now can file a claim before the liquidator. I mean, that is one solution. But of course, then there is no guarantee whether JSW will get the money, right? Because at the end of the day, JSW must get its full money first. That is the whole situation. So everyone will have to pay back. Okay.
The question coming up is something which, will JSW be liable to return all the profits earned by BSPL? JSW took over.
Well, okay, I've understood the question, sir. Let me answer this way. JSW was running the company BSPL, right? Please tell me, friends, if they were making the sales, they were making the sales in the name of the company. They were incurring expenditure in the name of the company because monitoring professional would be doing that in the name of the company only. So the profit is also belonging to the company. Profit has not gone into the pocket of JSW. I think let's understand. JSW is now handing over, you see, the entire thing because they were running the company, right? They were in the kind of management of the company, of course, under the supervision of the monitoring professional. So they will just walk out. That's all. So companies, its bank accounts, its books of accounts, records, they stay with the company. And stay with the company means now they will stay with the liquidator. I don't think it's a question, sir.
Unless there is a dividend declaration, and that may not be.
Unless they can't. Since the plan was not fully implemented, they could not have taken a money. That's what I can believe, sir.
No dividend was declared, sir.
Diverted the money somewhere else, that's a different question.
Since dividend declaration, nothing has happened. So the question is out of question.
Correct.
Sir, whether a strict compliance of completion of CIP timeframe will violate the natural justice, especially in case of home buyers matter.
Sir, all we are saying is nobody is saying that if you don't comply within 270 or 330 days, your time limit is over. Supreme Court is not saying that. Supreme Court says unless you take extension. So take extensions. If NCLT grants extension, well and good. If they don't, then it is then the matter ends, then the company has to go into liquidation. And then again, don't go on emotion, sir. Whether it is home buyers, whether it is steel industry, let's not care about that.
The touch
We actually get into emotions actually. So let's not get into emotions.
with you. In one case in NCLT Kochi, after 330 days, there was an informed decision taken by the CoC, and adjudicating authority gave a very speaking order, and the order says daily CRP. Since it is more than 330, you please conduct daily daily CoC meeting, so that the time bound is, action is given more importance.
So the matter can be finished quickly. Correct.
It's possible.
Correct.
If the CoC is not adhering to the commercial wisdom, what can the RP do about it? That's from Vikram. Vikram is shouting. Vikram is actually on it today. Vikram is going on shout.
No. Let us understand. Let's understand. See, the point is, what is commercial wisdom? Let's understand. Commercial wisdom is number one, the decision that whether we should approve this plan or that plan. So whatever plan they have to approve, they have to approve, but they must do it within the time limit. One. Number two, they must also see whether the compliance of law has been done or not. But let's understand one thing. First, is it not the responsibility of the RP to make sure that the compliance of law is done or not? So if he is satisfied, then naturally CoC automatically gets satisfied. So where is the question of non-exercise of the commercial wisdom? So typically speaking, if you point out that this law has not been compliant, that means you are pointing out the flaw against yourself itself. So therefore, Supreme Court says now commercial wisdom is much broader, not only the financial decision, but also compliance of laws. But that is also the primary responsibility of the RP to say so. Okay.
He's an officer of court also. Any implication or application of Section 238 implication with regard to PMLA and other statutory authorities from Prakash Kukreja.
Well, Prakashji, I think we have to take it with a pinch of salt because the Supreme Court says PMLA is a public law. So you have to understand, like even GST is also a public law. Similarly, there can be other laws which can be public laws. So if they are public authorities, then this will equally apply to all statutory authorities, right? According to me. Okay.
Here, so Udayji, you can take it from the your this one suggestion which you have made. And since you're here, I'll not read it for you.
I was always wondering that there are no comments on behavior of the legal fraternity. I assume that everybody has taken legal advice and then proceeded on the actions that they have taken individually. There is not even a whisper about any legal advice or behavior of legal fraternity in advising these stakeholders. And I'm really surprised to see that.
I have selective deafness, Dr. G. I only get certain things.
So now Mr. Patwardhan says, I'm not hearing it. I'm not hearing you because we are lawyers. Okay, good. Chalo, sir. I think a lot of questions are there and a lot of hands are also there. So let's do it quickly now.
Yeah, sir, it is very surprising to note that all big lawyers and big four process advisors were involved in the process. How could no one observe that even section 30 subsection 2 was
See,
not?
I'll tell you. See, at the end of the day, sir, there may not be any perceptive action today against any of these law firms. But at the end of the day, don't you think their reputation has taken a toll?
Yeah.
Somebody who has advised JSW, will anybody hire them now? So definitely, sir, it's a matter of reputation. If you give a wrong advice and something goes wrong to the client, naturally your reputation also suffers. And in profession, like in IPs, even advocates survive on reputation only, by the word of mouth, by the word of trust only, isn't it? So I think indirectly everyone gets affected, or even lawyers will get affected. Okay, yes, sir.
Vikram ji again, was liquidation the only answer? In liquidation, JSW will now be ineligible to participate, yes or no?
Right.
Question is whether JSW will be able to participate in liquidation stage process is the question. That's not answered by, but when it comes to 29A, if
29A has to be seen again. So if they are able to convince the RP or liquidator that we are 29A compliant, very good. But Supreme Court has already made that they were non-compliant. So typically speaking, they will be barred, according to me.
CA Amrit Raj says, Honorable Supreme Court could have ordered for fresh round of bidding process to identify another viable resolution.
Uh, I, I was expecting this. Sir, let me tell you why they have not done it. On the one hand, they are saying Section 12 is mandatory. On the one hand, they are saying that NCLT should not have even considered this application. Now, how can they consider? So therefore, friends, they did not do that. And please understand, all of us are under the impression that there has to be a resolution plan. The company must run as a going concern. I'm sorry. Look, go to the BLRC. Even liquidation is also a resolution. They say, see, timely liquidation is also important. And what will happen? Supposing one steel industry goes under the water, don't you think two others will crop up? Somebody will buy their assets in liquidation, put up a new plant. Somebody will see that value. So therefore, let's not be bothered about these kind of things. I think this is we should not go emotional on these things, right? So I think the Supreme Court has done fantastically well. They have ordered liquidation, and they say Red 12.1, 31.1, read with 33 clearly says if the plan is implemented, is not implemented, the company has to go to liquidation. I think the law is now very clear. Okay, sir. Yes, sir.
to Deshpande, plan passed through RP, CoC, NCLT, and NCLAT too. Undoubtedly, there were certain procedural lapses by non-compliance with regard to IBC, which cannot be denied. At top level of judiciary level, the questions pertaining to preamble of objective of the court are expected to be deliberated. The intent of lawmakers should be implemented in letter and spirit than the procedural lapses. Is this ruling represent the intent of IBC?
This is what I said. See, most of the people are saying these are procedural lapses. But my dear friends, these are not procedural lapses. There is something which is known as due process. Due process of the law is what it lies at the heart of this ruling. So Supreme Court has said that no matter how much time has passed, the resolution plan which does not meet the legal standards, it will not be allowed to stand. This is a fantastic and a powerful message, my dear friends. So let's not take procedures, you see, in a lighter manner, right? So that means Supposing you have not taken a visa, there is a procedural lapse. Can you enter any other country? Should you be allowed to enter the country, any other country? No, that's not like this. So law has to withstand, isn't it? So procedural lapses are also important lapses, so which are mandatory in nature. So typically, Supreme Court could have ignored if there was only one lapse or two lapses, but there was a fraud which was played. So fraud cannot be the basis of the approval of the resolution plan. So let's understand, friends, this case, this judgment turns on the facts of its own case. In another case where there is no fraud, there may be minor procedural lapses, Supreme Court may ignore it. And you will remember there have been 20 cases of IBC by the Supreme Court where Supreme Court has invoked Brahmastra, Article 142, and have ignored. You look at the JP case, they restarted the whole process. Didn't they do that? Because they simply said, all right, there is no other lapse which is there. So they can ignore, but not the frauds. They cannot ignore frauds. Okay. Yes, sir.
You are, law is above all.
Correct.
What about the Mr. Mukesh Chand Jain? What about the lawyers and advocates who fought on behalf of RPCOC? With regard to lawyers, I have got selective deafness. I will not comment on that.
All right.
Right. CS Madan Vaishnava. What will be the fate of IBC as all stakeholders are not doing their duties except IBBI? There is nothing against IBBI.
Sir, IBBI role is very limited. They are only simply monitoring, regulating, those kind of things are there, and probably making good regulations. So they have done their duty. They are doing the amendments and all those things. See, point is not. Let's not say that the fate of IBC gets affected by just one case. Now, out of say 1,000 cases, one case goes to Supreme Court and it is defeated like this. Well, 999 approvals have been done. Let's look at that. The success of IBC lies there, not in one defeated case. So I'm happy that no fraud, that it should not be a ground for manipulation, sir. Right? So it's a lesson for all the stakeholders. That's what we are trying to learn on this. Okay. Yes, sir.
And picture abhi baki hai. Well, let's see how the IBBI is going to act on this judgment.
IBBI must be happy with this. Okay. Yes, sir.
Impact of, again, Mr. Vikram, impact of judgment on PRAs.
Sir, I'm repeating 4 words. It is we must create a welcoming environment for genuine and serious players. IBC is not a playground for manipulation. I think that clarifies everything, sir. Okay.
Madam Suhasini, implication on SRA.
I think same answer, sir. Ditto. Okay.
S. Prabhakar, agreed that SRA did bungling and made to pay. RP may also be penalized, but what about others who have hand in glove? The CoC members, NCLT, NCLAT members who don't really come out clean. Why Supreme Court has not initiated, recommended any action against all those involved?
Yes, I think that's a good question. In fact, CoC, I think we have always said that CoC is the one of the body which is completely unregulated. I think now it is a time MCA along with IPPI must speak to RBI also that look, we have to bring in regulations for CoC's behavior. Of course, guidelines, CO's code of conduct is there, but if they violate? So that is the question which probably our friend is asking. So friends, let's do one thing. Mr. Patwardhan is also here. I think at IPNet we have given in on the WhatsApp group that we are going to create an IPNet think tank on policy, and I think many of you, around 50 people of you, I think they have expressed their consent. We have created a separate WhatsApp group. So we are going to start that. We are going to discuss all these issues, make proper representations to MCA regarding CoC, regarding whatever issues are coming. I'm not saying we are limiting the scope. Mr. Patwardhan is already here. He is going to design that. He is going to call first meeting, and those people who have expressed their interest, they will be invited. So please make sure that you attend such meetings, and with your experience, with your wisdom, I think we'll make better environment for RPs. So we'll do that, sir. Okay. Yes, sir.
There is one important question which has come. I think I'll just pick and choose because a lot of questions you have answered. So, can NCLT extend the timeline of repayment plan is in approved plan by NCLT. When CoC, SRA both are in consensus and NCLT on filing the application by SRA, extend the timeline of repayment plan by view of this Bhushan Steel order. Does NCLT have the power to approve it? Basically, he's asking whether modification is possible by Honorable.
He's typically asking about supposing the plan was to be implemented, say, in 1 year. Now it has not been done. So now they are seeking extension. So Supreme Court says the CoC, which has become defunct now they are simply the members of the monitoring committee. They do not have power to extend. In fact, they have mentioned in one paragraph, how did they extend that time? We are surprised. So they don't have powers. So typically speaking, you have to go back to NCLT and make a case that, look, we want. So you have to make a very strong case. NCLT, definitely, there is no express power, but they can exercise that power under Section 60. Under the circumstances, they can, in the interest of justice, they can extend that time also. Extension of timeline is there in Rule 11, there are many other rules are there. So look at that, they have got powers, they can do that, but they will not grant you like 6 months or 3 months. Probably they may grant you 15 days, 30 days, step by step. So let's do that.
I agree with you, sir. The case has to be so solid that otherwise you will step into liquidation. That should be very, very careful. Yeah.
Correct.
Mahendra Surekha, what happens to the assets attached under PMLA if they are part of the approved resolution plan in this case and in a normal correct process?
Mahendraji is a very, we have been interacting. So Mahendraji, I can just give you one advice, read section 32A. Okay. 32A is the answer to this question. Okay.
Okay, sir. Thank you.
Yes.
Ranganathan, when the facts are suppressed by SRA and it is clearly mentioned in the order of Supreme Court.
Correct. That is there, sir. Absolutely.
Advisors, should they not be taken into task? Already discussed. Sir, don't you think NCLT is not appropriate authority and RP to run pillar to pillar in different statutory authority? Then it will delay the process or even fail the CARP. Instead of approaching all the statutory, why can't NCLT be asked? That's the summons.
Divya, you are right when you say that, because in a large company that could be a case. In a smaller company, there may be one authority or two authorities, right? You are absolutely right. Naturally, you have to approach different forums and you have to hire different lawyers, different states could be there. I agree with you. I do not deny that. But then the law needs to be amended. So your observation, I think Mr. Patwardhan will take note of. Probably he'll discuss in think tank policy committee meeting and probably will make suggestions that these powers could land back to this on a certain, but this needs to be seen whether they will be constitutional or not, because constitutional law is to be seen. Anyhow, but this is a good suggestion. Will definitely requires more discussion on this.
Even if time is taken, you can always seek for exclusion also.
Correct.
JSW might have, Mr. Ajay Kumar, JSW might have spent on expansion of the project. What will happen to that investment? Now, who will be the beneficiary of profit made by the company post takeover? I think you have answered it, sir.
No, I did not answer for the expansion. Now there's an additional question. Supposing they have invested back, say 200 more crores, right? So some plant was not working properly. They brought in equity infusion was there. Well, friends, this was a business decision. There could be a business loss. So now they also become a claimant against the company, isn't it? So let them claim. Well, they'll file a claim before if this is there. I'm not sure whether it was there or not, but typically if this has happened, we don't know, then they can also file a claim.
Yes, it has happened. The capacity has been increased from 2.75 TPA to 4 point something TPA. Huge expansion has been done.
Then we don't know who did that, whether it was from the internal accrual.
Internal accruals or outside money. Yeah.
Right. If it is internal accruals, then JSW has no claim. But if they brought in separate money, then your question is right. Then we'll have to look into it. And probably JSW will make a claim or will make a separate application again to the Supreme Court saying, no, I must have top priority in that amount. So let's see that. We don't know. Okay.
Okay. SRA should not have played fraud. It's an opinion. All right. Ranjani, assessment done and 7A order. July 7A order passed.
It's me, sir. I may not be very expressive because I wanted to make it faster. Basically, the order was
This order makes it categorically clear that public law, when the RP has to approach the appropriate forum and not NCLT. But what if an order is passed during the CRP against moratorium? Can the
okay.
RP approach challenging that order, not on the merits, but
Okay.
passing of the order?
Rajni ma'am, the point is very simple. Assessment has been done under any law. Naturally, there is a process, there is a remedy available, right? So supposing income tax officer does, where have you the part? You have to go before the CIT appeals. So similarly, there must be some remedy under that law. So you have to approach it because typically speaking, NCLT does not have the jurisdiction, does not have the capacity to deal with PF department's things.
We are not talking about the merits of the case, sir. All we are saying is that it should not have been passed during the moratorium. It should have taken up during the liquidation. So during that period, it should not be taken up.
So that's all I'm
I
saying.
am only taking on the merits of that because what the PF department is saying that once an order is passed, it cannot be challenged. But at that point of time, the company was going through CARP and the information which is available with the PF department was not taken by them. So this is very genuine case of.
No, I've understood. So let's try to understand.
No, sir, sorry to interrupt you. Sir, say what is the implication of 238, sir? 238 is there, na?
I'll come to that.
Please, sir, please.
I'm only saying that during moratorium, you should not pass an order. You just cancel that. I will face it during liquidation.
Okay, I've understood. Let me deal with it in a broader fashion now. I think let's try to answer it. I mean, I may not be able to answer it fully. Maybe others can also chip in. Number one, insofar as the violation of the moratorium is concerned, according to me, the power lies with the NCLT.
Yes.
To correct that process, right? So if somebody is violating the moratorium, because there is a penalty section is also there. If somebody violates, so he can be taken to, he can be hauled up. So as far as simple moratorium violation is concerned, naturally NCLT will have the authority, whether it is public law or not a public law. Now the question why the public law has come in, because there is an attachment. PMLA is a criminal law. So Supreme Court says you are not a criminal court. How can you say this attachment will not be valid? So typically speaking, they are going into that. So let's distinguish between the seriousness in the sense that attachment and other things, and simply passing an assessment orders and other things. Those two are two separate things. So if there is a violation,
because there is a facilitation letter also given by IBBI, stating very clearly somewhere during January, it says that an order cannot be passed during CRP, but it can be done during liquidation.
Yes. Sir,
that makes a difference in my case.
I think I have seen that facilitation letter. I do not agree with the interpretation which has been given, because it is only a letter, it is not a regulation, so you are not bound by it. But as IBBI is given, naturally you are bound by it, you have to follow it. But all I'm saying is this is something which is very important for us to understand. The judgment which they have quoted in earlier paragraph, it talks about liquidation only. Now they have interpreted in a negative manner. They say, no, in CRP it cannot apply. I do not agree. So I think that facilitation letter interpretation is also not correct.
It's not there on the IBBI side. That letter is there, but we could not find it there.
It has been withdrawn. It has been withdrawn according to my information.
Okay,
that has been withdrawn now. Okay.
I get it.
What happens to fraud, Mr. Mahendra Sureka, what happens to the fraud committed by SRA if they get their money back?
See, as far as fraud is concerned, since they are misled, Section 74, they have already quoted. So they can be hauled up under 74. IBBI will be free to pursue that litigation, which they have done. As far as their money is concerned, money is a separate thing. Money has to come back.
Sir, I would want to answer to the Rajniji's January that letter, that order. It says that it does not prevent assessment or determination of tax liabilities. That is routine. So moratorium does not prevent that, sir.
No, there is a judgment of the Supreme Court also on that it does not affect the assessment, right? So that is anyhow. Let's go there further. Yes.
What if there was a loss during the implementation period?
So loss belongs to the company only, na, sir. The point is it's a going concern. So loss also belongs to the company, profit also belongs to the company. So loss is not going to be compensated by JSW. Why should they compensate? They're not taken any money out. It was in the coffer. See, let's understand. It was CD which was being run. The CD's bank accounts were being maintained. Now money was not going to JSW's account. So whatever profits and losses, supposing you are running a company doing CIRP, company makes losses. So will RP be responsible personally? The answer is no. So it belongs to the CD only. Okay. Yes, sir.
You already addressed what happens to an investment capex made in the plan by JSW for getting long-term benefits. I think
Entitled for refund, sir. They are entitled for refund. Yes.
position of capex by JSW, how it will be settled.
File a claim. If nothing happens, stand in a queue then, or move an application, settle the law that we get first priority over this. We don't know.
Divyesh, what happens to assets sold during this period? What about any new loans taken for the expansion or upgradation?
Devesh, I believe that no assets would have been sold because the plan was being implemented. It was not fully handed over to JSW. So during implementation, typically there are restrictions. One can run the company but not sell the assets. We don't know the facts. If it's a hypothetical question, if that has been done, probably it will be taken care of. Okay.
Next question is Gupta. Section 29 certificate is a huge task, considering it may involve checking across multiple sources, including cross-border checks for RAs, bar promoters. How can RP certify 29A? Should a legal opinion be taken?
Yes, sir. Process advisor, come legal advisor. You can take whatever help you want. In fact, IBBI has also initially they were of the opinion that RP has to do himself, and they were not allowing the expenditure. But now it is a well-established process. You can spend a reasonable money with the approval of the CoC. Appoint a process advisor to check that 29A. But it has to be done, sir. That's the bottom line. Yes, sir.
Rakhavendra, as the resolution plan is not implemented as per the timeline, why can't the payment made by SRA cannot be forfeited by order by Honorable Supreme Court or direct the Honorable NCLT before passing liquidation?
Okay. Well, it could have been done if there is a failure. It has been done in one of the cases where the SRA brought in 10 crores. I dealt with that matter. We went to the Supreme Court. It was not implemented. Supreme Court ordered liquidation and they said forfeit the 10 crore which has been paid by the SRA. But it could be done depending upon the terms and conditions otherwise. But at the end of the day, let's look at a broader picture. There can't be an unjust enrichment to anyone. Okay. If there was a clause that on a failure of the non-implementation, this would be there, then probably this could have been done. Yes. I think the liquidator, you are giving a hint to the liquidator now. All right. Okay.
Anil Katia says disproportionate also refund undertaking of CoC was in place. Yeah, that's Dr. Singhvi has committed on 20 in 20.
Yeah, that Singhvi has committed, yes.
Rakhavendra, why should the operational creditors should refund as the affidavit was furnished by the financial creditors?
So that is all right, but the point is they can't be doing unjust enrichment. Now supposing, let's take an example. In liquidation, you are paid in order of priority as per section 53. Today, some OCs might have got the money, but in liquidation, they may get zero. So how can they get benefit? Now that is an unjust enrichment. So if we are reversing the process, we have to reverse the process entirely. So even though those people will have to pay back, right? And then once the money comes to the coffers, it will be distributed out of the assets of the company. This is fair play, sir. Okay.
Mr. Anil says, OC who has not refunded cannot file claim.
Naturally, he's absolutely right. I think he's answering a lot of questions. In fact, he's assisting us. So I think I agree with him. Okay, go ahead, sir.
Sir, one of the key issues is identified in improper funding. As the Supreme Court observed, IBC mandates that resolution plan must be funded through equity. What will be the implication of those resolution plans that were also financed with debt?
Okay, if they are financed with debt, now that is a big question. But I'll tell you one thing. If they have been financed with debt, debt would have been taken by whom? Debt would have been taken by SRA, not by the CD. Right? Because CD is right now under implementation. I don't think anybody is going to fund it at this stage. So therefore, if it has been being taken by SRA, so SRA is responsible to pay it back to them. Otherwise, whatever equity he has given, he is entitled to take it back. Yes, sir.
All right. So Mr. Anil says SRA could not clearly demonstrate compliance of the infusion of equity as committed. Yes, one has to be clearer commitments straight in.
Correct. He is right, sir. He is answering
Sir,
that.
I would just like to add to that particular question. I'm Devang Sampath speaking, sir. Now, there is no ban on infusion through other means. The problem was the plan said they'll be bringing equity of 8550 crores. 100 crores of equity was brought in. Remaining of 8450 was compulsory convertible debentures which was brought in. So they had violated the plan. That is why this issue came in. If the plan said it will be coming through borrowing or through some another means, it was perfectly fine. And the explanation they gave is they were not sure whether the plan would continue or it would be challenged at court or set aside by court. And for that purposes, they brought compulsory convertible debentures in violation of the plan with approval of the core group. That was a problem over here. So borrowing is never a problem.
No, I don't know, sir, where you are taking that, because as far as Supreme Court judgment, it doesn't talk about compulsory convertible debentures. Then nothing is mentioned there. If you have seen the plan, then it's a different issue. But at the end of the day, they say that we have paid 8,495 crores to the CoC members. So that is what say, if you have paid it, you have to bring it back. So if it is CCD, then that will be cancelled. That's the end of the matter then. Instrument cancelling is much easier than returning the cash. Okay. Yes, sir.
It is the due diligence and finding about the details hitting 29A. Legal opinion may or may not be required. That's a subjective thing. It's always better to take.
Correct. That he's also answering the earlier question. Okay.
The issue, Mr. Ravindra Bellu, the issue is also to do with all expenses incurred from the date of order until Supreme Court, under Supreme Court order. Aren't they in more or less in similar nature of CIRP expenses? As long as there is a positive EBITDA there cannot be any return of money by suppliers.
There are two things. Let's try to understand. There is a judgment by NCLAT itself. What happened in one of the cases is that CRP expenses were there. Plan was under implementation. RP was to get certain fees during as a monitoring agency. He was supposed to get say 2 lakhs per month. Now he continued, but the plan failed. So after 6 months, the company was liquidated. Now the question that arose before NCLT was, what is this nature of the fees which is paid during the implementation period, 6 months multiplied by 12 lakhs and maybe some other expenses also. So what is the nature? Is it equivalent to CIRP? Is it equivalent to liquidation expenses? There is a judgment already by the NCLT, not by NCLAT. NCLT says it is not in the nature of CIRP. It is not in the nature of liquidation expenses. It will not get the priority under Section 53. It will be treated as operational creditors. Okay. So I think there is a clarity there, sir. So whatever expenses during that period has been incurred, naturally, if it's on a going concern basis, naturally those suppliers will be paid, but they are not equivalent to CIRP. They are not equivalent to liquidation expenses. There is a judgment to this effect. Yes, sir.
Mr. Kashi Vishweshwara Rao. During this IBC process, RP by liquidator are submitting the status of the process through various reporting systems.
Okay.
Then based on the reports, the IBB could also have monitored the happenings in at least high value cases and intervened in the matters to protect the IRP, RP and liquidator.
Sir, I will not say that. Let's keep IBBI out of this. The more it monitors, all RPs will be issued show cause notices. Let's not do that. Why do you want to bring government into it? You are competent to look at this. So let's not bring government into it. I never agree with that particular aspect. Okay. Let's not do that. That's not the IBBI's role also. Of course, they monitor at a level. Supposing there is a delay in approval of the plan, don't RPs get an email from IBBI? What is happening? Naturally, you get emails also at occasions. So they monitor in a different manner, but let's not do like this. Okay, I think, sir, there are a lot of questions. We are already at 7:16. I don't know how long we can continue because I don't want to you see, stand between them and their other activities. But anyway, we can continue for some more 10, 15 minutes.
10 minutes, because
We can be fast now, sir. Yeah.
what will happen to all those resolution plans which were accepted after statutory time limit with the argument that value maximization and survival of operating and viable corporate debtor is of paramount importance, whether all such cases will be reopened as decisions of Honorable Supreme Court is considered as a law?
So that will not happen. Whatever has happened, unless somebody has filed an appeal and it is pending on that particular ground, because the appeal has to be filed within certain time also. If that time period is gone, then the matter is over. So I don't think so. Whatever has been approved has been approved. It is not it is not changing the status of every case. It has changed the status of this case only. Let's understand. Okay. The principle of law which has been established, that is for future. It doesn't apply retrospectively. Okay.
The opinion says JSW cannot participate in any resolution plan. The opinion coming in, Section 29A will come into play. This will be
Correct. So for every case, they will see whether they are competent or not, right?
Shekhar and Gupta. Sir, the case of Vashana is part in the matter of ED attachment got judged by NCLAT, and it is the LIE syllabus conducted by IBBA. Will this case law after this judgment has any relevance?
See, the point is whether relevant or not, at the end of the day, Supreme Court judgments are more relevant. But Supreme Court has not gone into those minute details. In fact, there are already cases which are pending before the Supreme Court for final outcome, whether IBC prevails over a PMLA or not. So we are still waiting for those judgments to come. There are few judgments here and there, but we don't have a conclusive judgment so far. Okay.
Kashi says RBI should also have monitored, not just Kashi's opinion is since
Anyway, I mean,
my intention is that it is at the instance of RBI these dirty dozens were identified, and they should have monitored. That is my intention.
I believe they would have been monitoring. It's not that they must be asking SBI or PNB what is happening in this case. Probably they must be taking some reports.
Dr. Tripathi asks, in the wake of Supreme Court judgment, can IBB or RBI take any action against CoC?
No, sir, they don't have power. RBI also doesn't have power, sir. So this is what we are going to put up before the authorities, that there should be provisions for regulating them.
CA Gauri says, sir, why through this judgment guidelines for CoC can conduct are laid down? Why through this judgment guidelines for CoC conduct?
Gauri, you will remember that there was a Delhi High Court judgment which said IBBI should frame the conduct and that should be made mandatory, which the IBBI has done it. So it is already in place. This judgment does not lay down the guideline for the CoC conduct. It simply observes on the conduct of these. But how they should conduct, they are not saying, but some guideline has come from here. Okay. Yes, sir.
And again, Mr. Anil says an opinion. CoC has to be disciplined. Madam Ranjini, you can ask the question order yourself. Okay, Madam asks, this order makes it categorically clear that for matters involving public law, the resolution professional
Yes,
must...
it's the same thing.
Yeah.
It's the same thing.
Yeah, I think we have already covered this. Yes, sir.
Previous release, Section 238 applicable to PMLA. Question.
Sir, this question is pending before the Supreme Court because this is not an easy answer. 238, friends, I think all of us must understand, and I've been advocating this. It is not plain and simple that IBC law overrides all other laws. No, please read Section 238 carefully. It says if this law is inconsistent with any other law, if they are talking on the same subject, PMLA is on a different subject altogether. IBC is on a different subject. So according to me, 238 doesn't come into play. So therefore, this fight is already going on. It is pending before the Honorable Supreme Court. Let's await for that landmark judgment. Okay.
Arvind Kapoor, we also had received a resolution plan which was conditional, and they tried with CoC to accept it. However, CoC in his wisdom heard RP and rejected the plan. It's just an opinion, sir. Good practice.
I think Mr. Arvind Kapoor is saying that, look, this is also possible. If you advise properly, give reasoning to the CoC, I think they'll have to hear it. So I think he's done a good job. So we must commend that. Okay, great.
Mr. Ganeshan asks, Bhushan's RP's role will be investigated by IBBI and disciplinary proceed expected interrogation. Yes.
Well, he's also one of our fraternity members. I don't want to comment anything on this. That's between him and IBBI now. Okay. Yes, sir.
Arun Kapoor. Mr. Arun Kapoor was mentioning the capacity and first phase exemption with certain numbers.
Okay. But I don't know, but we are not aware whether this expansion was done out of internal accruals or by funds from JSW. So it will typically depend upon that. Okay.
So Prashant Jain says, so now IBC versus PMLA is settled that IBC does not prevail over PMLA. Is it being settled through this Supreme Court order?
No, sir. Supreme Court is not saying that. It is not a judgment on that. They are simply saying NCLT does not have a power.
NCLAT.
NCLT and NCLAT, both. So they do not have powers because this is a public law. So typically they are saying you have to approach authorities under PMLA Act only to get that order vacated, number one. If they don't do it, go to the appellate authority. If they don't do it, go to High Court or Supreme Court. Follow the process. Follow the judicial discipline. That is what.
Yeah, Mr.
Sir,
Vaidyanathan.
but that question was also pending, IBC versus PMLA, which where the SG has given a statement in the court that they are the two ministries are reconciling. Where
Correct.
that is standing as on date?
Sir,
Sorry, I interrupted you.
No, Mr. Prashant, that is still pending. As I mentioned 2-3 times, it is still pending before the Supreme Court. We are awaiting that landmark judgment. Okay.
PMLA is a criminal law, and on the attachment are.
This could be one of the reasons. Yes, sir.
Mr. Prakash, we ask, sir, time is essence. While in law, it is good judgment. Role of NCLT and NCLT raises serious concerns of credibility of the system in our country. It's just an opinion.
Time is the essence for this webinar also. But you are right, time is the essence. I fully agree with you, sir. NCLTs and NCLATs, if they have to come out with the credibility in the system, I think they need to perform better. No doubt about it. I'm not mincing my words. A lot of my friends are sitting in NCLT, but at the end of the day, we have got every right to constructively criticize them. Okay. So I think we will make some, you can say, representation on this, and we have been doing it also, right? Okay.
Person by name iPhone to ask a question.
Doesn't matter, sir.
What happens to the regulation if the regulation is modified to prohibit sale as a going concern during liquidation?
That is a proposal that they want to delete this. So let's hope. If it is deleted, then you can't sell it as a going concern. Then it has to go in a liquidation straight away.
And probably this only question.
Okay, chalo, great. I think we had a great time. So anyhow, friends, before we leave, still we can spend 6 more minutes. If anyone wants to have their opinion, their expert opinions, we'd like to hear from you.
It's just always a privilege to hear you, actually. I have to say that. Been hearing you for the last 1 year. It's fantastic, actually. Thank you, sir, for your wisdom. Always hearing the wisdoms.
Okay, thank you, sir. Thank you. Anyone who would like to contribute? Mr. Reddy, I think you would like to speak something.
Good evening, sir. Mr. Ashish ji, very nice presentation, sir. Excellent. There is no competition for excellency in IBC matters to you, sir. Sir, I want to ask you one question.
Sir.
What are the exceptions to 238, sir? Now you told PMLA, any other law, just for understanding of all people.
No, I'm simply saying there are no exceptions. The only thing which you need to check as a legal thing, and I will draw your attention to Macquarie versus Shilpi Cables, right? Do you remember that judgment, sir? Whether an advocate can send a Section 8 notice or not. Now, the Supreme Court considered Section 230 because that was argued that, IBC prevails over Advocates Act also. So Supreme Court looked at Section 45 of the Advocates Act. Supreme Court looked at Section 238 of IBC. They said, let us understand whether both of them clash or not. First, you have to find out whether they are inconsistent or not. The answer lies there. Now, then the Supreme Court said, Advocates Act operates in a different sphere altogether. It empowers the advocates to represent their clients, and IBC operates in a different insolvency zone. So therefore, there is no clash, there is no inconsistency. So therefore, 238 cannot apply. So please remember, sir, 238 applies only when there is inconsistency between the two laws. Let me read 238. Just let me take out the book. Let us read the opening sentence of section 238. I think that will clarify all doubts of all my friends here. Good question, sir. 238. Okay. Yes. The provisions of this code shall have effect, notwithstanding anything inconsistent therewith contained in any other law. So typically they are saying there has to be an inconsistency between the two laws. Only then 238 comes into play. If there is no inconsistency, then there is no question of one act riding over the other act, overriding the other act. Yeah, Mr. Patwardhan has placed it here also. Great, sir. Okay. Anyone else who would like to share his comments or any doubts? Because tomorrow, let's not try to say that this is, you see, breaking the IBC ecosystem. No, it is not, according to me, right? It is rather strengthening. In fact, let us remember the word strong. S stands for sanctity of the process. T stands for transparency, which is reinforced through this judicial scrutiny. R stands for reliability of the IBC, which has been restored. O stand for outcomes are tied closely to the process integrity, because everyone is saying process can take a toll, but the outcome is more important. No, outcome is tied closely to the process integrity. So O stands for outcomes tied with the process. N stands for no tolerance, right, for manipulation or non-serious resolution applicants. And G stands for global confidence, which is typically coming from fair and predictable insolvency ecosystem. So remember the word strong. Okay. So I think I thought I'll give that across to you.
Sir, Ashish sir,
Yes, sir.
Good evening. This is Bala. Sir, one last question. Can
Yes.
IRP, it is a already decided matter, you know, whether IRP can reject a claim submitted by a financial creditor stating that it is a time bar date?
Yes, sir. Why can't it be done?
Yeah, sir.
It has to rather see today the law has changed slightly. So just go through that law, because there are two things. One is it has to come within the time period, which is 14 days from the date of CIRP. Second, then 90 days time period is there. Then thirdly, now it has been extended up to I mean approval of the the CoC meeting in which it is placed for I think EOI. I think it is up to EOI now. So those kind of things, you'll have to look at those provisions now. Okay.
Sir, so my question is, they have submitted well within the 14 days.
It is a time bar date.
Yeah, it's a time bar date. Already it is a 3 years lapsed or 12 years lapsed.
Correct,
so there is no, yeah.
You're bound to reject that, sir.
Yeah, that is why, sir. Stating that it is a time bar date, so it cannot be accepted.
Sir, I'll tell you how you have to visualize this.
Yeah.
You are RP of a company, you are the MD, CEO, board of director of the company, isn't it? Supposing
yes.
the company had not come into CIRP, somebody asks for the money, what the MD would have done? MD would have said it is a time bar debt.
Yes, sir, obviously.
So the same decision you will have to take, because you are wearing the same hat. Okay.
Yeah, correct, sir. If the same financial creditor files an appeal application under Section 7, obviously it would be rejected, sir. It's the same thing. So it is a time bar date.
You're absolutely right. So if the NCLT is not entertaining because of the time bar, so naturally you will also have to reject that claim.
Yeah, sir. Yeah, that is why. To clarify our paternity, that is why I asked this.
Correct.
Thank you.
Correct.
So my simple question is that because of this case, the IP has to meticulously follow the timeline also and see the things properly. That is the message given by this case.
Absolutely, sir. In fact, timeline to IP is in any case bound. Today, I must tell you, IPs are getting show cause notices from IBBI and also from IPAs. Even a 3-day delay, 4-day delay, 5-day delay in making a public announcement, in issuing IM. I mean, you are getting notices if it comes under inquiry. So you are typically answerable. So you are bound by the time limit in any case. And most of the RPs are doing in time. 1 day, 2 day, 3 day, 4 day, here and there. I think that is merely procedural lapse. That is not an intentional lapse. But yes, sir, you are always bound to do that. Okay.
Sir, I think that in the light of this Supreme Court judgment, the responsibility of IPNet has increased. has to be to inculcate the ethics, to
Sir,
refresh on the timelines.
Sir, one more thing. I think we are now serious people now sitting here. Out of 250 who joined, now we are 112, right? I believe they are all serious people. That is why they are sitting here.
260 Ashish.
Yeah, 260 plus. So now let me pose this question to you. IPNet can become stronger if you involve yourself. It can't be done by 15, 20 or 30 people who are right now in regional committees or executive committee. Now, what I'm doing, what I want from all of you, all of you have got IPNet WhatsApp now, this thing, or you have my number also, right? Otherwise, I'll put my phone number right now. Please show your interest that we would like to become a regional committee member. We have got 5 regions now: North, South, East, West, and Central. So depending upon where you are located, please send me your this thing interest. We will involve you actively in organizing the programs, in organizing the study groups, in organizing whatever discussion you want, like think tanks or whatever. So IPNet will become strong because of you, sir, right? Not because of Mr. Patwardhan or because of Mr. Panicker or because of me, but we want to make it stronger because of the involvement of all IPs.
I
So
want to be a
just
part of think tank, sir. I've
absolutely,
given my name to.
I have noted your name. I have noted your name, but anyone who wants to do that, just send me an SMS, and we are going to consider expansion of all the regional this thing. We will definitely consider you, right? And we'll take you there in there. Mr. Hari Prasad, are you ready, sir?
Yes, sir. Yes, sir.
Absolutely, right?
Well,
So I've noted down 2 names just now, okay? And I believe Mr. Reddy is also there, right? Mr. Reddy will also be a part of it, right?
My request is that all the senior guys should also help the new people to help in the procedural part also sometimes.
Yeah, now, Mr. Joshi, you are right. In fact, Mr. Panicker also mentioned that we should have a kind of a refresher course for all the IPs, right? Somebody who became an IP in 2017, I know they have done so many cases, they are all experts. But since the regulations have amended, typically we have a tendency not to read sometimes or maybe miss that, isn't it? So I think we have to conduct some advanced programs also. So I think that's a good suggestion by Mr. Panicker. We are going to do that, but for that again, we need more faculty. Right, all programs can't be done by me or Mr. Patwardhan or Mr. Panicker or Ms. Ranjani. We 4, 5, 6 people can't do that. We need more faculty. So please, those who are experienced people, please come forward. Send me a WhatsApp that I want to be a faculty. I'm an expert in this subject. Let's share our knowledge with the new IPs who are coming in. I think that's a good suggestion Mr. Joshi has given. I think everyone should start maybe regionally only, right? Let's not do it on a pan-India basis. Let's start 20 people. Physical meeting also, I don't mind. Let's start that process now. So every IP should take responsibility of holding that. We are going to do that, sir.
An intention to help each other, that for that.
Absolutely, sir. Absolutely. Absolutely.
Sir, small this one, sir.
Yes,
sir,
sir.
This problem of RP in this case happened not because he doesn't have knowledge or he is not advised properly by the best of the legal brains. So in our cases also, what is happening is that, no, let me complete, sir. In our case also, what is happening is that in this spur of the moment or for some reason, we may miss. Obviously, in this case also, that kind of thing only would have happened because otherwise we can't say that he didn't have knowledge of the full subject or he was not advised properly. So how do you advise us that we should not have this kind of a lapses? Because, okay, what you say is right, sir, because we should have full knowledge. After having full knowledge also, we may make a mistake. But we should not make a mistake without knowledge. That's what my feeling is. Just
Good question. Good question, sir. So I will answer it like this. We at IPNet and IP fraternity is very large today. A lot of experienced people like Manoranjani ma'am has done so many cases. Mr. Patwardhan has done fantastic number of cases, right? Somebody is good, has a good experience in real estate. So what we can do is we can establish the experience of those people, put it on the website. Like supposing you are handling a real estate matter and you have some questions to ask you, maybe you can approach Mr. Patwardhan because you know that he has done some cases. So we are trying to do that. Number one. Number two, besides that, you can't do alone, right? That is very important. I always say, create a team. You have to have a fantastic team. So if a large case comes, naturally you will have process advisors, you will have a legal team to advise you properly on those issues. But please also make it a point. Sometimes you blindly go on a lawyer's advice. Oh, I was advised by a lawyer, but that also can go wrong, because I got some IBBI cases where RP acted on lawyer's advice, but it was a wrong advice. So how do you do that? So typically, that is why your knowledge will also come. So don't take the advice on the face of it. Try to examine it, try to discuss it with your IP friends. I think if you take some opinion from your IP friends, right, you'll get a lot of confidence in that. Like supposing you have got some matter in South, so you can approach Mr. Hari Prasad, Mr. Reddy. A lot of people are there. I mean, I'm just taking name at random only. So you can approach those people. They said, sir, I need your help. I need your advice. If he can't give an advice, he may refer it to somebody else. Like I get a lot of calls. Oh, sir, I need advice on Provident Fund. I said, Mr. Narayan Kamma. He was PF commissioner. He's a part of IPNet. He has been in very number of seminars.
He's just too good. He's too good.
He's too good.
Now.
So actually, my question, I am asking his number from last 4-5 days, but I am not getting his contact number.
Kamma Narayana.
I think Mr. Manoranjani can share it on the hair itself. Otherwise, you can connect with me. I'll give it to you. Okay.
Thank you very much, because I am writing to all the admin of this IPNet, but nobody is giving me that.
IPNet, sir, they are admin people, na. They may not be knowing it. You have to approach IPs, na.
Okay.
IPNet ke group pe डाल. Are you a part of IPNet WhatsApp group or not?
Yes, sir. Actually, that is only the admin. So only admin can give that. Only admin can share. No? Okay.
Already shared.
Already shared. Now it is already there.
Pramod Srihari has shared it.
Thank you very much, sir. Thank you.
Chalo, great. So this is what happens. So friends, we are expanding regional committees. Please give me your interest. We are creating a panel for more faculties. Please give me your names, right? And think tank, if you want to be a part of it, we will involve you. And we will be able to strengthen IPNet just because of your contribution or your involvement. Okay. So thank you so much. I don't want to speak too much now.
Thank you very much, sir.
Over to Panicker for the closing words, or maybe Mr. Patwardhan, right? Because you have also done.
Mr. Patwardhan. Yes, I can thank both of you very honestly. I can tell that this much of analysis of that particular order has not been done by anybody. As you have rightly pointed out initially, those who have read the order and those who have not read the order all had opinions. And the other one was bigger. They would read some newspaper article and form an opinion. And even after you read an order like I had done, not really we were able to really analyze it the way you have done it, sir. So I must thank you for such a detailed analysis of the order and its implications on the fraternity and the care that will be required to be taken by all so that better resolution will prevail. And no doubt Mr. Sankar Panicker did an excellent, wonderful moderation of the whole session. And I'm thankful for him. And participants, no doubt, had issues. They discussed it very properly and were addressed by all the faculties and Mr. Ashish and Mr. Sankar also. So we have been able to come out with some satisfaction that this is no longer a puzzle, but we have resolved the puzzle and we now have the solutions as to how to proceed. So with this thoughts in mind that this is no longer a problem, but we see a solution in this order, not a problem in this order. So that is the take home according to me. And with that, let us proceed. We will, as Dr. Ashish had just said, we will be having soon a committee meeting on any reforms that we would look into the IBC process. Maybe it's in the legal process or otherwise. I would expect contributions from everybody so that as an IPNet group, we grow stronger, we approach stronger, we appear stronger, and we become successful. When RPs become successful, we are the pivot of the process. So if we are successful, whole of the process is successful. That is what I believe. Thank you very much. Have a good evening ahead.